Thank you for visiting the Combs Waterkotte YouTube channel. We are a leading criminal defense law firm in Illinois and Missouri, with over 600 perfect reviews and a long history of client satisfaction, criminal case dismissals, charge reductions, and victories. Our firm has created these audio articles to help protect your freedom, reputation, and rights. If we are hired for your case, we will not give up until you receive fair justice. Aggravated Vehicular Hijacking Lawyer. Chicago, Illinois. Being charged with aggravated vehicular hijacking in Chicago, Illinois is very serious. Carjacking is treated as a severe felony under Illinois law, often carrying lengthy prison sentences, large fines, and life-altering consequences. At Combs Waterkotte, our criminal defense lawyers have decades of experience defending clients against violent criminal charges like aggravated vehicular hijacking. Our team takes the time to understand every detail of your case and develops a strategic defense aimed at protecting your rights and minimizing the impact of your carjacking charges on your life. Call 312-500. Help to put a dedicated legal team in your corner to fight your Cook County aggravated vehicular hijacking charges. Aggravated Vehicular Hijacking Lawyer serving Chicago and all of Cook County. Aggravated vehicular hijacking charges in Chicago and throughout Cook County carry some of the most severe penalties under Illinois law. Prosecutors often pursue these cases aggressively, seeking lengthy prison sentences and harsh consequences that can follow you for the rest of your life. You shouldn't face charges of this magnitude without a skilled team of defense lawyers on your side. At Combs Waterkotte, we understand that allegations of aggravated vehicular hijacking can arise from mistaken identity, false accusations, or rapidly escalating situations. That's why we begin every case with a thorough confidential consultation to hear your side and evaluate the details. From there, our experienced attorneys build a tailored defense strategy, carefully analyzing evidence, challenging witness accounts, and identifying weaknesses in the prosecution's case. Whether negotiating for reduced charges or preparing for trial, we are committed to fighting for the best possible outcome for your Chicago carjacking charges. If you're ready to protect your future and take control of your case, contact Combs Waterkotte online or call 312-500-HELP today. The sooner you have an experienced Chicago defense lawyer in your corner, the stronger your position will be. What is aggravated vehicular hijacking in Chicago, Illinois? To understand aggravated vehicular hijacking charges in Chicago, first, it's important to understand the vehicular hijacking statute of the Illinois Criminal Code. 720 IILCS 5/18-3 says someone commits vehicular hijacking when they knowingly take a motor vehicle from someone using force or the threat of force. Certain aggravating factors elevate a vehicular hijacking offense to aggravated vehicular hijacking. 720 ILCS 5/18-4 defines aggravated vehicular hijacking as committing vehicular hijacking against someone with a physical disability, against someone 60 years old or older, while a person under 16 years old is in the vehicle, while using a dangerous weapon, including a firearm, while shooting someone with a firearm. These specific victim groups and the use of a weapon or firearm constitute aggravated vehicular hijacking under Illinois law. How the dangerous weapon or firearm is used and the extent of the injuries they may cause determine the penalties for an aggravated carjacking offense. What are the penalties for aggravated vehicular hijacking in Chicago, Illinois? Aggravated vehicular hijacking is always charged as a Class X felony, the most serious felony charge on the books in Chicago and Cook County. Class X felony prison sentences range from 6 to 30 years or 30 to 60 years for an extended sentence, and since a firearm is always involved in these cases, an extended sentence is likely. The Aggravated Vehicular Hijacking statute goes on to define instances where additional years in prison are added to a defendant's sentence, depending on how they used a firearm during the offense. These additional years in prison are added to any other prison sentence the court may impose, and they include a 7-year minimum sentence for carjacking with a dangerous weapon, other than a firearm, 15 additional years for carjacking with a firearm, 20 additional years for discharging a firearm during a carjacking, 25 additional years to life in prison for shooting the victim during a carjacking. On top of these lengthy additional sentences, the prosecution may feel compelled to stack an additional aggravated unlawful use of a weapon, AUUW, charge. If convicted, this sentence will run consecutively to any other prison sentences incurred from the original aggravated vehicular hijacking offense. Criminal defense strategies for aggravated vehicular hijacking cases in Chicago. It should be clear by now that aggravated vehicular hijacking is one of the most serious criminal offenses under Illinois law. Despite that, a criminal defense attorney can still provide a good enough defense to get the charges reduced or even dismissed. At Combs Waterkotte, we've defended Chicago residents against carjacking charges in the past. Here are some of the criminal defense strategies we've found to be most effective in getting our clients the best results possible. Challenging the presence or use of a firearm. Aggravated vehicular hijacking charges in Chicago can hinge on whether a firearm was actually present during the offense. Prosecutors must prove more than mere suspicion. There must be credible evidence that a real weapon was used. The defense may challenge inconsistent witness descriptions, lack of physical evidence, or absence of a recovered weapon to argue the firearm element cannot be proven beyond a reasonable doubt. Disputing firearm enhancements and allegations. Even if a weapon was allegedly involved in the carjacking, the specific enhancement matters. Illinois law imposes steep penalties depending on whether the firearm was possessed, displayed, or discharged. A defense attorney may argue that the facts do not support a heightened enhancement, like disputing whether a gun was ever fired or whether it actually caused an injury. If successful, this argument can potentially reduce sentencing exposure significantly. Challenging eyewitness identification. Aggravated vehicular hijacking cases frequently rely on victim or bystander identification. Carjackings are often fast, stressful, and may occur under poor lighting conditions. A defense attorney can challenge identification procedures, highlight inconsistencies, and question reliability to create reasonable doubt about whether the defendant actually was the person involved. Fourth Amendment violations: illegal search and seizure. If police recovered key evidence, like a weapon or the vehicle, through an unlawful stop or search, they may have violated your Fourth Amendment rights, and that evidence may be suppressed. This is especially critical in aggravated cases where the presence of a firearm elevates the charge. Suppressing improperly obtained evidence can significantly weaken the prosecution's case. Miranda rights. Statements made during police interrogations may be excluded if law enforcement failed to properly advise the defendant of their Miranda rights. In aggravated vehicular hijacking cases, prosecutors often rely on admissions. Challenging whether those statements were obtained through Fifth Amendment violations can limit the state's ability to prove key elements of the offense. Lack of accountability for co-defendants' actions. Many Chicago carjacking cases involve multiple individuals. However, Not every participant is automatically responsible for a co-defendant's use of a firearm. The defense may argue that the defendant did not know a weapon would be used or did not participate in the aggravated conduct, which can be critical in avoiding enhanced penalties. Reduction to possession of a stolen motor vehicle. If the prosecution cannot prove force or threat of force, the charge may be reduced to possession of a stolen motor vehicle. This is a major strategic goal in many cases, as it removes the violent felony component. The defense may argue the incident involved unauthorized use or possession rather than a forcible taking, potentially reducing a decades-long prison sentence to just a few years, or even probation. What to do if you're arrested for aggravated vehicular hijacking in Chicago? When you're arrested for a felony offense like aggravated vehicular hijacking in Chicago or Cook County, what you say or do in the hours after your arrest are critical. If you take the right steps, you can significantly aid in your criminal defense. Though the situation may be overwhelming or intimidating, it's important to stay calm and remain aware of your legal rights. The criminal defense attorneys at Combs Waterkotte recommend doing the following if you're arrested for aggravated vehicular hijacking in Chicago. Invoke your right to silence immediately. After an arrest for aggravated vehicular hijacking, clearly state that you are invoking your right to remain silent and that you want an attorney. Do not engage in conversation with Chicago or Cook County Police, even casually. Officers may continue asking questions to elicit statements. A clear verbal invocation helps protect you and limits the prosecution's ability to use your words against you later. Contact a Chicago defense lawyer. Aggravated vehicular hijacking charges carry severe, often mandatory prison sentences, especially when a firearm is involved. Contacting a Chicago criminal defense lawyer as soon as possible allows for early intervention, including evidence preservation and case strategy. The sooner an attorney is involved, the better positioned you are to protect your rights and begin building a strong defense. Do not try to explain away firearm allegations. In aggravated carjacking cases, statements about a weapon can be especially damaging. Trying to explain whether a gun was real, present, or used can unintentionally support the prosecution's theory. These details carry major sentencing consequences, so avoid discussing anything related to weapons and allow your attorney to address those allegations strategically based on the evidence. Avoid contact with co-defendants or witnesses. If multiple people were allegedly involved, do not communicate with co-defendants or potential witnesses. Prosecutors may interpret contact as coordination or intimidation. Even well-intentioned conversations can complicate your case. Let your attorney handle all communication and investigation to avoid creating additional legal risks. Document your whereabouts and timeline early. As soon as possible, begin documenting your memory of events, including your location, who you were with, and any relevant timing. This information can help your attorney identify alibi evidence, surveillance footage, or inconsistencies in the prosecution's case. Early documentation is critical before memories fade or evidence becomes harder to obtain. Prepare for detention or strict release conditions. Aggravated vehicular hijacking is a serious offense in Chicago, and judges may impose strict pretrial conditions or even deny your release. Be prepared for electronic monitoring, travel restrictions, or even jail time. Your attorney can advocate for your release, but understanding the likelihood of restrictive conditions can help you plan appropriately for the next stage of your case. Combs Waterkotte is a leading criminal defense law firm serving the entire states of Illinois and Missouri. We have offices in St. Louis, Chicago, Kansas City, Clayton, Branson, and Belleville. We look forward to helping you with your criminal defense attorney needs.